Hi everyone, welcome to Legal Talks by Desi Qanoon. I am Suyash and I am excited to have started this show. On today's show, we will talk about another latest judicial pronouncement by the Honorable Supreme Court of India in the case of Compack Enterprises India Private Limited versus Beant Singh. This case involves a civil suit in which the High Court had passed a consent decree directing the petitioner to pay the respondent certain sums of money till date the petitioner hands over the actual possession of the suit property to the respondent. There was a civil dispute between the parties relating to an immovable property, and the High Court recorded the compromise between the parties and passed a consent decree directing the petitioner to pay the respondent certain sums of money till the actual possession of the suit property is handed over by the petitioner to the respondent. However, in this process, that is, while recording the consent decree, some terms and conditions and some clerical and arithmetical figures were incorrectly and inaccurately recorded by the High Court. That is, there were some clerical and arithmetical errors in the consent decree. The petitioner, aggrieved by this, preferred a review petition before the High Court, which was dismissed by the High Court, holding that there was no error apparent on the face of the record to justify its review jurisdiction, and that the petitioner was dishonestly trying to wriggle out of the consent decree by attempting to overreach the court. Thus, the petitioner was constrained to approach the Honorable Supreme Court. What were the observations by the Honorable Supreme Court? The court said that the consent decrees are intended to create estoppels by judgment against the parties, thereby putting an end to further litigation between the parties. Therefore, normally, the courts are hesitant to unilaterally interfere in modifying or substituting or modulating the terms of a consent decree, and it is done by the court with the revised consent of all the parties thereto. At this juncture, it is important to note that Rule 3A of Order 23 of the Code of Civil Procedure 1908 talks about bar to the suit if a compromise has been entered into by the parties, and if the court has passed certain orders on such compromise, then the parties are precluded from bringing a suit with respect to the same cause of action. At this juncture, it would also be profitable to read the contents of Rule 3 of Order 23 of the Code of Civil Procedure 1908. It states that where it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part by any lawful agreement or compromise in writing and signed by the parties, the court shall order such agreement, compromise, or satisfaction to be recorded and shall pass a decree in accordance therewith. There is also an explanation appended to this rule. It states that any agreement or compromise which is void or voidable under the Indian Contract Act 1872 shall not be deemed to be lawful within the meaning of this rule. Thus, I hope that the mandate of Rule 3 of Order 23 is clear now. And in order to further understand what is a consent decree, we shall peruse the judgment of Ruby Sales and Services Private Limited versus State of Maharashtra 1994 1 SCC 531. This judgment stated that merely because an agreement is put in the shape of a consent decree, it does not change the contents of the document. It remains an agreement and it is subject to all rights and liabilities which any agreement may suffer. Having a stamp of court affixed on such an agreement will not change the nature of the document. A compromise decree does not stand on a higher footing than the agreement which preceded it. A consent decree is a mere creature of the agreement on which it is founded and is liable to be set aside on any of the grounds which invalidate the agreement. So I hope that the nature and the mandate of consent decree is clear to the audience. In the instant case, the court cited the case of Bairam Pestonji Gariwala versus Union Bank of India and others, 1992 1 SCC 31, wherein it was held that a consent decree would not serve as an estoppel where the compromise was vitiated by fraud, misrepresentation, or mistake. Further, this court, in the exercise of its inherent powers, may also unilaterally rectify a consent decree suffering from clerical or arithmetical error so as to make it conform with the terms of the compromise. So what was held by the court? Upon considering the aforestated position of law, the court held that though it would be cautious in exercising its inherent powers to interfere in a consent decree, yet in the present case, upon perusing the entire record, the court was of the view that there are errors and inconsistencies in the consent decree that are apparent on the face of the record. Hence, the court found this case a fit one to exercise the inherent jurisdiction to correct the terms of the consent decree in order to bring it in conformity with the intended compromise and the agreement. Thus, the court directed the parties to comply with the modified consent decree. So what are my concluding remarks? I think that in the instant case, the court explained its power to rectify a consent decree in order to make it conform with the terms of the compromise. Though it is true that no modification in a consent decree should be made without revised consent of all the consent parties, yet in extraordinary situations where there is a deadlock that has arisen due to an error apparent on the face of the record in the consent decree, and such error is not consistent with the terms of the compromise, the court can very well modify the terms of the consent decree to do complete justice to the parties. We also see that civil litigations usually take decades to reach to an end point, and a consent decree in such cases is a valuable tool to preserve the precious judicial time of this country and also the time of the litigants. Mere clerical or arithmetical errors should never come in the way of dispute resolution, and the courts should keep an open mind to correct such errors. So I hope that you enjoyed listening to this show. Thank you for listening. See you next time. Till then, stay tuned.